Welcome to Paradigm Shifts, new thinking about our changing times with your host, Harriette M. Steinberg, practicing matrimonial and family law, real estate, trust and estates, and elder law. You can watch episodes on YouTube and listen through Apple Podcasts, Spotify, Google Podcasts, Stitcher, and more. For prior episodes, go to www.lawyersonli.com. Now here's the host of Paradigm Shifts, Harriette Steinberg.
Hi, welcome to another episode of Paradigm Shifts. I'm Harriette Steinberg, also known as the Divorce Sherpa. I'm an attorney practicing in the areas of matrimonial law, elder law, trusts and estates, and estate planning. My process of choice when working with clients is mediation or collaborative practice. In each episode of Paradigm Shifts, you will hear from a professional who has important information to share about changes in lifestyle. We will be looking at issues involving divorce, aging, finances, death, retirement, and more. And you can find this show on YouTube, LinkedIn, Apple Podcasts, and more. So, today it's my pleasure to introduce a colleague, Scott Mandelup, who is a partner in the firm of Pryor and Mandelup. Scott assists people with all kinds of financial issues. So, good morning, Scott.
Good morning, Harriette. How are you?
I'm good. So you're the money man, one of the money men, I would say. Let me ask you this question. I would bet that you get this question a lot. Has the pandemic affected money issues for your clients?
Absolutely. Probably one of the biggest paradigm shifts that we've seen in over 35 years of doing bankruptcy, debtor creditor, and commercial litigation. And it was a major shift because some of the major incentives for considering bankruptcy counseling, bankruptcy planning, and bankruptcy or the non-bankruptcy alternatives to financial problems come from evictions, foreclosures, civil litigation, particularly for businesses, foreclosure of security interests in business assets, those kinds of things, all of which ground to a halt shortly after the pandemic started. Coupled with the fact that the state courts basically shut down, there weren't trials being scheduled for a long time, all of that took away the emergency or the incentive to even consider those kinds of bankruptcy kinds of alternatives to financial problems. So there was a moratorium, literally, and then coupled with the fact that a number of individuals were receiving government aid, all of that created a situation where bankruptcy was less urgent and less turned to for the better part of the last 2.5 years.
Wow.
That has now changed as now evictions are being scheduled and happening, foreclosures are being scheduled and happening, state courts are back live for all proceedings now, in our area certainly, and the federal money has dried up. So now people are now having to deal with the rents they didn't pay, the mortgages they didn't pay. Businesses are getting to a point where they have a little more certainty as to what's going to be in the future, so they can start considering whether they need Chapter 11, those kinds of things. So we're seeing the beginning, I'd say, of a major shift. The floodgates haven't quite opened yet, but everyone seems to think that it's coming, and that the bank.
So you're what I'm hearing you say, Scott, we're now after the pandemic, we're going to have a tsunami of issues, financial issues.
No,
Yes.
a lot of people think that that's what's coming. Certainly, creditors are starting to ramp up. They have the ability now to do what they couldn't do before. So it'll either mean a lot of negotiation and resolution of foreclosure issues, landlord-tenant issues, business issues, litigation, and then that usually leads to increased bankruptcies.
So, what kind of people would you say bankruptcy can help?
Bankruptcy helps a variety of people and situations. It can help consumers with significant debt that they can't otherwise handle, that they're never going to get out from under, particularly if they're in a point where going forward, if they didn't have the old debt, they would be able to support themselves and deal with, and their families, and deal with debt on an ongoing basis. It helps people who can help people who have mortgage foreclosure issues, eviction issues. It helps businesses that need to buy time to get back on their feet and deal with their old debt and small bankruptcy dollars. It can help a lot of situations. Sometimes there's litigations that there's no way to resolve other than, with a bankruptcy. Sometimes the willingness to consider it as a bargaining tool in a litigation situation. And then there are non-bankruptcy alternatives also. But when they're coming from the perspective of what's possible in a bankruptcy, they have a tremendously higher chance of success because they're taken seriously.
Well, what types of bankruptcies are there?
You have three primary types that you'll hear about. You have Chapter 7, which is a liquidating bankruptcy available to individuals or businesses, where a Chapter 7 trustee is appointed whose job is to liquidate the non-exempt assets for the benefit of creditors. You have an automatic stay in all the bankruptcies from the time of the filing that prevents creditors from taking action against the debtor or his or her assets without first coming to bankruptcy court to get permission. You have the discharge for individuals, and in Chapter 7, you have the discharge of most of their obligations. There are exceptions, like for matrimonial obligations, recent income taxes, and other things, but most average debts are discharged, wiped out in a Chapter 7. And then you have exemptions. There's a choice between exemptions in the bankruptcy code and exemptions under state law. And these enable an individual debtor to protect various assets, including significant equity in a home, and a motor vehicle up to a certain number, things like that. So it's always an analysis of which exemptions to use, but those are the main elements of a Chapter 7. If a Chapter 7 isn't viable because there's assets or there's a business, there's the possibility of a Chapter 13, has certain debt limits to qualify, and that's a payment plan bankruptcy, like a mini reorganization for individuals with regular income, where you pay your creditors at least as much as they would have gotten in a Chapter 7 over a 3 to 5 year period. The Chapter 13 trustee is different. They collect the money and they disperse it. They make sure the plan is confirmable, but they're not looking to sell the debtor's assets. For the less invasive type of trustee. And then you have Chapter 11, and the Chapter 13. There was a Technical Corrections Act for the Bankruptcy Code signed into law by the president on the 21st of this month that made Chapter 13 more available. It increased the debt limits to $2,750,000 for all debt. That's in effect for 2 years, so that's made 13 more accessible. 13 is great for mortgage foreclosures, the classic use for it, where you stay the foreclosure, you want to keep the house, you cure the arrears over the life of the Chapter 13 plan, say 5 years, and you stay current on your normal mortgage payments going forward from the time you file. It's a very powerful tool, and it works with other assets you want to keep also. The Chapter 11, right at the time of the pandemic in February of 20, unrelated to the pandemic, there was an amendment to the bankruptcy code that created a new subchapter 5 of Chapter 11 for a new small business 11, which had debt limits of 2.5 million, but during the pandemic they increased it to 7.5 million.
Wow.
And this new law just put that into effect, at least for the next 2 years. So that's a much more streamlined, intended to be a more streamlined Chapter 11, a more affordable Chapter 11, and a faster process. Now, the pandemic made it a little difficult to take advantage of it because you have a short period of time to file a plan, and businesses have to know where they're going. But now, with businesses getting back to normal, I would expect that to be taken advantage of much more. So those are the basics, and there's a normal Chapter 11, which can be used by individuals with businesses or assets, but it's usually businesses, and a much more expensive and complicated process.
So, Scott, when you do the Chapter 13 for, let's say, a small business, and you have a payout plan, is there interest, or does everything get frozen at the time of the bankruptcy and you pay out that amount of money? Or does it keep growing during the bankruptcy?
Well, first, the 13 is only available for individuals. So if you have a sole proprietorship, it works. If you're the owner of a business, it can help. There was talk about, but there is no 13 for businesses. It's the small business 11 is the closest, and is similar in many ways, but is closest. With respect to your question, things are usually frozen. If they're oversecured, they're entitled to interest, but generally speaking, it's frozen as of the filing date, and it varies, but that's basically the way it works. It depends what we're talking about, really.
So, when should a client or someone who's having financial issues or problems come to or start thinking about bankruptcy, which would mean coming to you, the professional? Yes.
Yeah, that's a great question, and the short answer is as soon as possible, because there are things that can be done for both businesses and individuals to plan for the possibility of a bankruptcy. The more time the attorney has, the more that can often be done. One of the more difficult situations is the client that comes in and says, my house is being foreclosed tomorrow, my business is being evicted tomorrow, there's a judgment entered against me yesterday. Those you're much more constrained as to what you can do if you have to file that day or tomorrow. So the answer is early, and of course this cuts against the way most of us think, because when you have these kinds of problems, they are often, next to health, the most important thing in the world and the most onerous, and nobody wants to think about it. Nobody wants to deal with it. So just like we put off calling the doctor, we put off calling the bankruptcy attorney, and that's unfortunate. And people should realize that making that call early may mean there's nothing you need to do now. It may mean here's some things to do and come back in 6 months, or come back if it gets worse, or maybe there's a non-bankruptcy solution that's available now that may not be later. So it doesn't hurt to get a consultation when you think you're having trouble or you think you're headed for trouble, because then you'll walk away with good ideas of things to do, and you'll feel there'll be some weight lifted, because you'll be told most likely that your problems can be dealt with either now or in the future, or how to deal with them. So it's a very tough thing. We see this all the time. People just agonize and sometimes they'll call and they'll come back months later, often when the situation is worse. So yes, it's a difficult thing.
You know, as you speak, it reminds me of something I've seen in the work that I do as well, you know, whether it's matrimonial work or even just marriages that are having problems. You know, people with the advent of the web, everybody thinks they're a professional, that they can figure out what their problem is. And I mean, I've been guilty of that myself in many areas, but I'm learning just listening to you that I think the key to your message is know what you don't know and come to find someone that can give you the advice that really will be the value of your problem to your problem.
Like any expertise, Harriet, and I certainly wouldn't want to advise somebody on how to do a will or get a divorce. There's nuances, and bankruptcy is complicated because not only is it a particular federal statute and a lot of case law, it also touches on every other area of the law, and in particular ways. And for example, if somebody's got financial problems or their spouse has financial problems and they're contemplating a divorce, timing is an amazing tool or burden in that, and you have to be informed about it. And practitioners in other specialties aren't necessarily informed about it. The really good ones know what they don't know, as you said, and they'll bring in a bankruptcy attorney or they'll consult one, because you can do things that can't be undone later on, and that had they been done differently would have a very different effect for the debtor party or the non-debtor party.
That certainly is a good way to handle paradigm shifts. So, Scott, how can we tell our viewers where to connect with you and the firm with their issues or problems? What's the best way to reach you?
Our phone number is 516-997-0999. We have a website, pryormandelup.com. We're available by email. My email is asm@pryormandelup.com, and we always welcome calls or emails, and be glad to help anyone we can. We get a lot of our clients come from attorneys, as you know, and accountants who refer to us. So they're professionals that people consult for other things. Many of them know that when they need to consult a bankruptcy attorney or tell their client to. So that's another way.
Well, I guess we've pretty much exhausted for the moment the introduction to Pryor and Mandelup and bankruptcy issues. I want to thank you for giving us your time and look forward to working with you on other issues. Thanks.
Pleasure.
Thanks.
Thank you for listening to Paradigm Shifts, new thinking about our changing times, with your host, Harriette M. Steinberg, practicing matrimonial and family law, real estate, trust and estates, and elder law. You can watch episodes on YouTube and listen to Apple Podcasts, Spotify, Google Podcasts, Stitcher, and more. For prior episodes, go to www.lawyersonli.com.